So welcome everyone to another session of law and policy discussions. Today we'll be talking about climate justice, particularly about the recent or the very recent uh, General Assembly resolution through which it invoked the advisory opinion of the International Court of Justice regarding international obligations of states regarding climate change and the damage it has caused or it has the potential to cause in the future, and how we can recover the reparations. Right. We have a couple of questions regarding that, and we have our learned speakers. And I think, Amira, you will start, and then we can continue with that.
Yes, sir. Thank you so much. Greetings, everyone. My name is Amira Husheed, and as we are discussing the obligation of states and international law to ensure the protection of the climate system and other parts of the environment from harmful anthropogenic gases or emissions of greenhouse gases for states and for present and future generations. So firstly, we need to explain what is the legal framework under which the states are obligated to protect the environment, and under which we can make the states responsible for the harmful climate emissions that they are having, that they're part of. So the first convention that I really want to talk about is United Framework Convention on Climate Change. According to the Article 2 of this United Framework Convention, its objective is the stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. So this treaty or this convention really shows that its objective is that the dangerous anthropogenic interference of the greenhouse gases are to be reduced. So all the members who are the members of this United Framework Convention of the United Nations, they are under an obligation to stabilize greenhouse gas concentrations in the atmosphere so that they cannot interfere in the climate system and we can have a better climate environment. And its Article 3 also talks about the principle of precaution, which is really crucial to discuss here, because we can relate it to that when the states are involved in some kind of situations where there are harmful, there is a possibility that harmful greenhouse emissions are taking place. They should take precautionary measures that the other states or that any kind of activity which is harmful to the climate is not happening. So here the principle of precautions kicks in. The second convention that I want to talk about is the United Nations Convention on the Law of Sea. It does not talk about the climate change categorically, but it provides the states under Article 192 that the states have the obligation to protect and preserve the marine environment, including rare and fragile ecosystems as well as habitats. So when the climate activities affect the marine environment, because the sea levels are increasing, because the floods are increasing, it has an effect on the marine environment. So states are in obligation under this particular treaty that they should protect and preserve the marine environment. So they should not do any activity which harmfully impacts the marine environment. The other really important agreement is the Paris Agreement, which of 2015, and it is a landmark multilateral climate change process, and it is a legally binding international treaty on climate change. And under this treaty, governments set targets known as nationally determined contributions with the goals of preventing the global average temperature from rising 2 degrees Celsius, so that the green gas emissions can be reduced and we can have reasonable climate system available. So under this agreement, the states are under responsibility. So under the responsibility that they take actions which can make the global average temperature of the globe below 1.5 degrees Celsius. So the countries or states which are party to this agreement, they have the responsibility that they are involved in activities which do not rise the temperature of climate to 2 degrees Celsius. Because when the temperature rises, it turns into global warming, and which is actually the issue for which United Nations General Assembly invoked the advisory opinion of the ICJ. Then the next thing which I really want to discuss is the state obligation with respect to the rights which are expressed in international conventions and treaties. Firstly, there is International Covenant on Economic, Social, and Cultural Rights, which states that everyone has the right to enjoy the benefits of science and applications. All the states should actively support the development and dissemination of new climate mitigation. So under this specific convention, the states have the obligation that if they are contributing in new climate mitigation policies, everybody has the right to enjoy it. So the states are under an obligation to make possible those climate mitigation adaptation technologies so that the global average temperature of the globe can reduce, and because of that reason the harmful gas emissions can be reduced. The second really important principle is principle of due regard and transboundary harm. The principle of due regard is now regarded as customary international obligation under Principle 2 of 1992 Rio Declaration and Principle 21 of the Stockholm Declaration. So the principle of due regard is really important in this case because the states have to set out a balance that they have the sovereign right to exploit their resources under environmental policies, but they are responsible for ensuring that the activities do not negatively spill out beyond their territory or areas of national jurisdiction. So if a state is involved in an activity which is harmfully impacting the climate, which in turn affects the individuals of the other states, so the states have the responsibility to protect those individuals as well. So the states have to take that due regard principle that their activities do not negatively impact their citizens as well as the citizens of the other states. And the next right, which is very important to discuss, is the right of life of not the present generation, but the right of life of the future generation as well. The emission of anthropogenic hazardous greenhouse gases greatly impacts human health and environment, as we have discussed before. And this has a direct nexus with the right to life, which has been enunciated in United Declaration of Human Rights, in ICCPR, International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, and other international and regional instruments as well, because they all give the right to life to individuals. But due to constant global emissions and constant harmful anthropogenic gases, the global warming is increasing day by day, which in turn is causing major climate changes, including melting of glaciers, extreme flooding. For this reason, human life is at stake. And the right of life is an inherent life of every individual, as we have stated above, and is also present in all the international treaties. So the states are under an obligation international law to protect the right of life of individuals. Hence, an immediate action plan is needed to cater the issue of hazardous emissions, because these emissions are not impacting the right of life of the present generation, because this harmful gases and global warming is harmful, impacting the resources which are needed for the future generations. So the right of life of the future generations are also at stake. Another important right, which is really important to discuss, is right to development. The Rio Declaration on Environment and Development, as well as the UN Declaration on Right to Development, talks about the right to development, and it to be fulfilled so as to meet equitably the development environmental needs of present as well as future generation, which is the topic of discussion, to protect the rights of not only the present generation, but also the future generations. So if the harmful emissions continue to happen and the harmful impact continues to take place on the environment and the planet, there will be no resources of favorable living conditions left for the future generation, which is a violation of the right of development of not of the present generation, but also of the future generations as well. So there are some important case laws which I also want to highlight in this important discussion. The first one is Sachi versus Argentina. In this case, although this appeal was not heard because it was because the children has not really exhausted the domestic remedies, but in this case, an important principle was discussed. In this case, the Committee on the Right of Child, CRC, accepted the claimant's argument that states are legally responsible for the harmful effects of emissions originating in their territory on the children outside their borders. So this is really important, that the committee accepted that if a country is involved in a practice which is harmfully impacting the individuals or the children of the other states due to that particular climate practice, that state is responsible for that practice. And this fundamental principle was also discussed in the Inter-American Court of Human Rights 2017 advisory opinion, and the CRC followed that particular test for jurisdiction. The committee found that when transboundary harm occurs, children are under the jurisdiction of the state on whose territory the emissions originated. If there is a causal link between the acts and omission of the state in question and the negative impact on the rights of children located outside its territory, then the state of origin exercise effective control over the sources of the emission in the question. So if there is a state who's involved in harmful climate practices, and because of that the children of other states are affected, that particular state who is involved in that harmful climate practice, that state will be responsible for the harm which is happening to the children of the other state. The other important case is the legality of the threat or use of nuclear weapons. In this case, the ICJ recognized that the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. So we also want to talk about the generations which are not present. So we have to make a living condition where the future generation can live peacefully. So ICJ recognized that the states have general obligation to ensure that their activities within the jurisdiction and control respect the environment of other states or areas beyond national jurisdiction is now part of the corpus of international law. And this is similarly which we talk about the CRC. The next case is pulp mills case. In this, the ICJ considered the principle of prevention and pointed out that as a customary rule has its origin in the due diligence. In this, the due diligence principle was also discussed. So the states need to be diligent of what harmful climate practices or what kind of practices they're involved in. And if these practices are going to be affecting the present or future generation, the states have to have regard of the due diligence principle. The last case which I want to highlight is Gapkikovo-Negimaros project case. In this case, the court emphasized the need for vigilance and prevention to avoid irreversible damage to the environment. So as we want to talk about the gas emissions and harmful anthropogenic gases which are badly affecting the climate. So according to this particular case, the court emphasized that there is a need to prevent or avoid irreversible damage. So these harmful practices are badly affecting the climate, are badly affecting the ozone layer. So that's why the people, not only the people, but also the planet is at stake. So the states under responsibility to get rid of the harmful practices which are contributing under the carbon emissions. And here I want to discuss a really important concept, which is the law of state responsibility in terms of climate change. As we know that there are principles known as responsibility of states for internationally wrongful acts. They basically recognize the principles that when the states are responsible for the wrongful acts internationally. Article 1 of responsibility of states for internationally wrongful acts provides that every international wrongful act is followed by an international responsibility. Two essentials are provided under Article 2, that the act or omission is attributable to the state, and this act or omission is a breach of an international obligation. It is only when the wrongful act can be established. So in our case, we are talking about the climate change, and we're talking about the harmful gas emissions or harmful anthropogenic gases which are affecting the environment. So first thing, that the act or omission. So when a state is responsible for harmful climate practices, they have industries which are contributing to gas emissions. So that act or omission is attributable to the state because the industries or because that state is particularly involved in that particular gas emission. So we can attribute that particular act or omission to that state. And we established that the states have the responsibility to protect the environment. We have established that under UDHR, ICSAR, under the principle of due diligence, under United Nations framework, Paris Agreement, states have the obligation to protect the environment, protect the life of the people, protect the life of not only the people who are present in their territory, but also if the activities is impacting the individuals of other territory, the states have the obligation to protect those. So if the states do not protect the environment, and if the states do not, so do you have a question? Am I audible?
Yes, thank you, Meera. So I would like to add a couple of things to your presentation. I think International Court of Justice clarified a couple of basic customary international law principles regarding protection of the environment. Under the cases of Gapchico, Nagimaros, and of course the legality and the advisory opinion concerning the legality of the threat of use of nuclear weapons. The first one is the equitable and reasonable use of a shared resource such as water and the environment. It means that no one owns these shared resources, right? So you have to use it in a way that is beneficial to everyone. And so it is called reasonable and equitable use principle, right? And you can't damage it, you can't stop others from using it, right? And you have to cooperate and collaborate with others in terms of utilization of shared resources. Secondly, is the no harm principle, which means that if a harm, nothing, you can't, act in a way through which your territory is used or can be used to harm your neighbors, right? So essentially, your territory cannot be used in a way that leads to harm to other states. So if you are running industries on your state, on your land, within your jurisdiction, and that causes pollution, that damages the environment, that causes climate change, which will eventually impact various states around the world, you are actually violating a customary international law principle, which is called the No Harm Principle, right? So these principles, these two basic principles, are also established in these cases by the ICJ, right? So you can also consider these customary principles when you are considering a legal framework pertaining to international state obligations concerning climate change or protection of the planet. So, other than that, Samia, Tanur, or Fida, if you guys have a question, if you guys have a comment, please feel free to ask. Nothing? All right. All right. Henson, you can continue. And I think please try to keep it within 10 minutes. You're not audible. You're not audible.
Oh, sorry. Thank you. So in my case, since Amelia has already pointed out a couple of international treaties that help us to understand what are the legal consequences. So I think it is a kind of direct, it is some kind of direct obligation that we, so far we use that treaties to ensure that all the member states are enforced to handled all their legal responsibilities. So in my case, I do focus on whether there are some kind of indirect implications about climate change by the member states. So particularly, I would like to point out the Paris Agreement. Probably all of us may have some idea from the news, since it is signed and ratified by 195 state parties. It do provide some examples for us to know what those countries should do, and particularly because in our following discussion, we talk about some impacts regarding the rights, the benefits of small islands in the coastal area. So in this case, I would like to say that the Paris agreements do provide some nationally determined contributions. So in this case, that all the countries that get themselves involved in the Paris Agreement, they are required to commit their part. So they have to outline their climate action plans. They have, let's say, they have to provide some kind of specific emissions reduction targets. They have their adaptation measures, and also they have other actions to combat climate change. So, and of course, all these actions are based on individual states' own circumstances, their capabilities, and also their priorities. So, all these actions, when they combined all together, then they will, just like what we have already mentioned, that they will have an ultimate goal to limit the global warming rate below 2 degrees Celsius. So they will like to reduce it into 1.5 degrees Celsius. And most importantly, we have, of course, there are a couple of measures as well, just like the technology transfer, the capacity building. That means there's some developed states will provide knowledge transfer, technological assistance for those countries who do not have the capabilities to do so. And of course, they will try to set up some funds to also some kind of special provisions to recognize the importance that they should provide all the necessary measures for the vulnerable countries, so that they can also make their own contribution to regarding climate change instead of just simply victimizing themselves. But of course, what I have to emphasize here is we do have that in the compliance mechanism. That means we don't have a specific law. We don't have any measures, so-called, to punish those state parties who failed to commit their goals. But instead, we don't. Since we don't, the Paris Agreement does not impose any legally binding sanctions on parties for their non-compliance. That I think we can use the Paris Agreement as a reference that we do have measures, and it is always possible for us to take a look to see if the agreement itself provides some of the obligations for the state parties to facilitate them to set a committee, to set up funds, to provide certain initiatives to promote and to make sure that they have the suitable actions for the parties. But besides this so-called international agreement, it is also important to see if it is possible to include in our future publications. We also have some kind of regional agreements, let's say the European Emission Trading System, and we also have the Amazon Cooperation Treaty Organization. Of course, in this case, as suggested by the name, apparently they are not specifically targeting climate change, but instead for these kind of regional agreement that apparently that they do provide us with some specific goals involving specific sectors. So in this case, that it seems that they do have these kinds of regional agreements to deal with certain factors that may influence the extent of climate change. And of course, we do have some kind of multilateral environmental agreements as well. Of course, we can provide more examples later on by our further research, but particularly I would like to point out the Montreal Protocol on ozone depleting substance. So probably many of us may consider, well, if the CFCs will cause an influence to the atmosphere, or somebody will simply illustrate it as, well, thanks to these kind of emissions that we actually create a hole in the South Pole, some sort of rumors like that. But even though the protocol's primary focus is not climate change, but so the protocol indeed provides some kind of significant benefits and climate mitigation. So because many of the ozone depleting substances are also greenhouse gases. So if we set up a goal like this to eliminate them, to reduce their emissions, that, and I must say, the protocol to a certain extent contribute to the reduction of greenhouse gases emissions. So in that case, I will say, so besides we have the international law, let's say, just like what we discussed in our previously, that we may have the International Court of Justice to provide us with some advisory opinions of what the measures, what are the attitudes that state parties should do to deal with climate change. But of course, when we take a look at some kind of other agreements, no matter it is international or regional, it's also possible to indicate that we do have some legal consequences for the state parties. And
Henson,
yeah.
I have a final question.
Okay.
So is it possible under the law state responsibility to attribute climate change and the damage it causes to any particular state or a group of states for the purpose of recovering or claiming reparations?
Well, I cannot say I don't know whether it is the stat update, but when I take a look at some of the information that I get, so well, just like what Amelia has already mentioned, that we have the Paris Agreement, we have the United Nations Framework Conventions on Climate Change, and thanks to these kind of international agreements, we do find out that there are certain funds that have been established. Let's say the Global Environmental Facility Trust Fund, the GF, and the Caribbean Planning for Adaptation to Climate Change Program, some kind of program like this. So in this case, that I realized that for these kind of agreement, for these kind of funds, they do provide financial support for some kind of small island developing nations, in particular to those, let's say, in the South Pacific region. So they do provide them some kind of technical support. They do provide them with some resources support, in particular to some kind of programs to raise the public awareness of climate change and try to put them. And I think I will consider this as a vicious circle. That means if these kind of countries, they do not have the sufficient technology, they do not have the sufficient knowledge, then it is not possible for it to, even though they know the awareness of climate change, they can do nothing regarding that. So in that case, if we have those funds that we try to improve their living by providing them with advanced technology, actually, it is a kind of obligations to help those countries to play their role in dealing with climate change.
All right, thank you very much, Henson, for the insightful presentation. All right, any questions, or do you want to comment or anything? Anyone? Nothing? All right, I'll wrap it up here. Thank you everyone for joining this insightful and very informative session, and we'll have the second part as well. It will deal with Pakistan and its climate woes and how it can maybe recover damages and how we can attribute state responsibility in terms of climate change. and the damage it has caused to the country, right? So thank you very much, and I'll see you soon.